Welcome to Notable Approvals. I am attorney Amanda Shaffer. I have a very exciting update on a previous case that I talked about to get to today. Before I get to that, I seem to have some lighting issues, but we'll just push through. Don't forget to like us on Facebook, YouTube, Instagram, wherever you are watching so you don't miss this or any more of our lives. So, and don't forget to hit that share button if you found this video to be useful or know someone who may. So last time that I did a notable approval was 2 Fridays ago. And I recommend going back and watching the replay. I was pretty pumped up. I had just finished court, had a huge win for a client. The family court agreed with us that the mom was wrongfully wrongfully retained, and what that means, as opposed to just taking the child. She had permission to take the child, but then she didn't give the child back when she was supposed to. So we said the court in New York didn't have jurisdiction over the parties for custody, but they had temporary emergency jurisdiction to make mom give the child back. And on Friday, we went before the judge. The judge agreed with us. She issued an order. It said my client could pick up his daughter the next day. He was ready to make the 10-hour drive. I hopped on the internet, on the social media, and talked about the case. I was really pumped up. Like I said, it is a really interesting case to get all the details about. And then a few hours after that, I get a call from the Deputy Clerk of the Appellate Division telling me that my opposing counsel had filed an emergency motion to stay and appeal the judge's order that was set to go into effect the next day. So this was like probably 4 p.m. that I was even notified this was going to be filed. 6 p.m. I'm on the phone with the clerk, and he's asking me for my client's position. Now, before I spoke to the clerk, we looked up. We were like, okay, what time does the court close? Closes at 5. All right. What's an emergency application? Is this going to be considered an emergency application? Because it's very rare for the appellate court to do anything on a Friday afternoon at 4 or 5 p.m., especially once the court closes. So I'm on the phone with him. I didn't even know my opposing counsel had gone in person, because there's actually a requirement for these types of emergency cases that you file in person. So he had to kick her out of the courthouse because the court was closing for the day. I'm losing my light. So he calls me and asks, basically, I'm sitting there explaining what happened at the court, because normally when you do appeals, you have time, you file the notice to appeal to put people on notice, and the judge on notice, and the appellate court on notice, and then you just put like a statement, and then you get the transcripts, and then it's called perfect the appeal by submitting your actual brief, and then I can submit an opposition, etc. So I was a little shocked because, and I think honestly the family court judge would have been shocked too. And I don't think any of us really thought that they would appeal, mostly because it seemed to be very straightforward that mom was in the wrong, and the judge had the authority to do what she did, and that these weren't people that were violating court orders left and right. This was the first time she had wrongfully withheld the child. So I was pretty shocked. I was getting ready for a friend's birthday when I got the call, and I had to sit there and explain to the clerk what our position was. That basically, that I explained, like, again, I'm not going to repeat everything. Go back. It's literally the video. If you go on our social media, it's the video from January 27th, the last one I did on notable approvals. And so I explained my position, and I say, okay, well, when are we going to know? Like, is the judge going to make a decision today? Like, is my client has to leave at like, 4 a.m. to get to New York in time to get his daughter in accordance with the schedule. So what time, are we going to hear from the judge? And he's like, I don't know. You might not hear until tomorrow. So, I mean, I tell my client, I don't know what to tell you. If we don't have a decision by tomorrow, I guess you could start driving. The worst case is you turn around. Obviously, I'd feel terrible if he went all this way and he didn't even get to, then had to turn around. But we had to wait. So I was checking my phone every few minutes. It was quite stressful. Did not go to my friend's birthday. And I found out around 8 p.m. finally that the judge stayed the order. And what a stay is, you may have heard like an injunction before. Basically, it just puts the order on hold. So what it meant was my client cannot go the next morning to pick up his daughter. It didn't mean that the order was reversed or thrown out or anything like that. It just meant temporarily it's on hold. So we were obviously really disappointed. I mean, talk about a roller coaster of emotions. So then, they had filed their notice of appeal and then they sent me their brief. And then in addition to this signed order to show cause that temporarily stayed the order, I was ordered to file an opposition appeal to the appeal by February 1st. So if you don't count the weekend, it's 2 days. Monday, Tuesday, and then by Wednesday morning it had to be filed. So I was not thrilled, because I really didn't think that the appeal had much merit. B, my client, I was crying in tears and then just like in shock. And it was just a really hard thing emotionally. Normally, emotions get involved sometimes, but as a lawyer, you need to stay a step away from it because you can't get too emotionally involved or you drag yourself down too. And this is one of those cases where, I tried to keep my distance. And then once I thought my job was done, I kind of let out a sigh of relief. And then all of a sudden I'm dealing with this. So it was pretty difficult to deal with. But I got my opposition filed and I explained that the judge had emergency temporary jurisdiction under the New York domestic relations law, which mirrors the Uniform Child Custody Jurisdiction and Enforcement Act, or the UCCJEA, and that essentially that there's a couple parts of the argument. Now, my adversary is supposed to brief the issues they want the presented or the questions they want the appellate court to answer, and they didn't do that, so I kind of had to guess. But essentially, they were saying the judge didn't have authority from the law to issue the order to return. And because it was technically a temporary order of custody, that it wasn't specific enough, because it didn't have a time certain. It said, well, until a court takes jurisdiction or further court order. And then it also said that there was no imminent risk to the child. So I explained, number one, the court clearly had jurisdiction over the matter. Again, if you go back to the previous episode, jurisdiction is one of those fun legal things that you spend your entire first year in civil procedure and you still don't even know where to begin with jurisdiction. So it's not an exciting topic. It's dry, and but I did talk about it a little. So I cited to the law, I explained it, and then I said, look, first of all, the judge did not have to make a more specific order. The law itself, and then I looked up the case law to see if there's anything different, didn't say that the judge had to make specific findings of fact and put them in the order. And there are certain things, like a perfect example is child support. When the judge orders orders child support, or you have a stipulation of settlement for child support, any type of written agreement, you have to put down what the child support would be according to the formula that's in the law. And then whether you're going by the formula or not, you can go higher or lower, but then you have to explain why. And if it's not, the order is invalid. So in this case, there wasn't any requirement that I could find, at least. So I said, number one, there wasn't a specific requirement. The order was fine as written. Number two, there was an imminent risk to the child, because even mere, wrongfully withholding a child from the other parent can be considered child abuse. It was emotionally and psychologically damaging. And then there was also a little piece of that statute that talked about the court invoking these emergency powers in order to take protective measures for not just the child, but it included the sibling and parent of the child. And we did explain that my client started having panic attacks, anxiety attacks, was depressed, couldn't sleep, was having trouble at work. And this all started because he never had any of these issues before. And it wasn't just him. His wife was having problems. Everybody was. They were just so distraught over the whole situation. And all of this was either written in my client's affidavit, which he swore under penalty of perjury, under oath. It was said by him when we appeared for the first time in court on Monday, or it was said by either him or me on the following day that we were in court on Friday when the judge issued the order. So we did talk about all the imminent risk of harm that would befall this child and the protective measures for the father that needed to be taken in order while everything else was playing out, because we don't know how long that will be, but we know that it is a finite period. So the court in Canada is already deciding jurisdiction. We just don't know when that decision is going to come out, but the opposition was already due. And in New York, the judge said, well, you have a hearing in April for custody. If Canada takes jurisdiction, there's no court in New York. But if New York wants to weigh in and talk to Canada, they can do that. And they can ask to speed up the court date. So I submit my opposition, and then I actually submitted it Tuesday afternoon. I was early because I just focused on getting that done those 2 days. And then a few hours later, my opposing counsel submits a letter to the court requesting leave to reply. What that means is that depending on the court, depending on the type of case, depending on the law, the courts and the local court rules, you may or may not, when you file a motion, so you file a motion and the other side gets to oppose the motion or, reply, gets to respond. And then in the court that we were in, they said, that's it. If I said something and the other side wanted to comment again, they had to ask the court for permission. And then technically there's something called a surreply where I get one more chance to reply, but I would still also have to ask the court for permission. And one of the ways that you avoid your opposition from requesting to reply is you don't bring up new issues. You don't cross appeal. Like I wanted to cross appeal for attorney fees and for sanctions, and that really would have been it. But I was like, I said to my client, it's not going to be worth it if this ends up pushing the deadline, because I didn't know if it would, because technically speaking, they may have done that. So I filed as simple motion or opposition as I can. Appeals are never easy because you have to really explain everything, but you also have to be succinct, and especially when you're doing an emergency appeal. So I see this letter from my adversary, and the clerk then emails back. She had to attach a reply. I read her reply, And it really didn't, I thought I pointed out the procedural defects. I thought she was going to fix those. She didn't, but I asked the court, can I write a letter in opposition? I don't need a SIR reply. I don't need any of that. I don't think she should be allowed to reply. I've had 2 days. They said they're not pushing out the due date for everybody was February 1st, 10 a.m., period. So I didn't think it was fair that she would get to reply. I didn't raise any new facts. And I openly admitted that because I didn't have the transcript, I was going by memory to the best of my ability. And her reply was just refuting the facts, trying to refute the facts, I guess, without it citing to anything. Basically saying that, one of my arguments was that when we talk about imminent risk of harm, the opposition in the family court never raised this as an issue, never said that there wasn't an imminent risk of harm. They never rebutted any of that. And it's because they were focused on their argument, which the judge wasn't I'm going to say buying, I guess is the best way to say it. The judge didn't find it to be a convincing argument. So I was, obviously frustrated because of that. And I said, look, they could have refuted these facts. They could have submitted an affidavit in opposition. They didn't. So they waive their right to argue it. So, and this is true of any issue and any fact in any case. When you're in the trial court, so that's the first court that you're in, if you don't bring up something, like if you think that your due process rights were violated, or your First Amendment rights, or that the facts that the other side wrote down or told the court is wrong, if you don't bring that up and say that you believe there is an error, or you don't state your position on the record, you can end up waiving your ability or losing your ability to appeal that issue or that decision. And the courts are very serious about that, because you need to do it right away. Otherwise, everything would get appealed. Nothing would ever be final. So that was part of my argument too. And then everything was submitted, and then we kind of just had to wait. And we didn't know how long it was going to take. And then I felt this past Friday, I had deja vu because I got a decision from the court at around 4 p.m. on Friday that said that the stay was lifted, meaning that the stay that put the order on hold, where my client could go pick up his daughter, that was now gone. And that said, and then actually they put in the date, February 4th, which was this past weekend. My client can go the next day, because the next day was Saturday, drive down, pick her up, and the other court order would remain in effect. And then in addition, they put a scheduling order in. So the appeal isn't over. They gave the other side 60 days to perfect the appeal, which means getting the transcript or the minutes from the family court, essentially, because all the briefs were already submitted and there's no oral argument. And then it goes to a panel of judges, and they can reverse the decision of the judge. They can vacate the order and reverse. They can remand. They could send it back to the judge to make a more specific order. There's all sorts of things they could do. And one of the things that the other side was saying, well, if you let the order go into effect, even while the appeal is pending, and dad picks up his daughter and goes back to Canada, there's no guarantee if they reverse the decision, he's going to return the child. And we were like, whoa, first of all, my client said under oath, yes, I will respect any court order in America or in Canada. And then as the family judge kept pointing out to the other side, you're saying that your fear, because they made this argument earlier, the week before, your fear is exactly what your client is doing right now. Not returning the child when someone's telling you to return the child. So it was a little ironic. But I was very relieved that they lifted the stay. And that meant that on Saturday, my client did pick up his daughter finally. It was the longest he's ever gone without seeing her. And mom cut off more communication with dad after that Friday hearing. Normally he FaceTimes with his daughter like every day, had it in over a week. She cut off his access for updates on the school app, the preschool app. So he was incredibly excited. And, what's going to happen now is really the question. Well, the appeal still has to be decided, but appeals can take a very long time. 60 days is a very long time to perfect the appeal. And that's because it can take time to get the records from the family court. And even if they do it right away, now we're in the regular line for the appeal. There's no more emergency. And there's lots of appeals that have to be decided. In the meantime, while this is going on, Canada is still up there deciding on jurisdiction. And if the opposing party decides in New York to file an emergency order to show cause to speed up their custody proceeding, that would mean that New York then had to talk to Canada, the courts there, and say, hey, are you taking jurisdiction? And they kind of have they can have a conversation with counsel, without counsel, but they're required to contact the court there. The court in Canada is not required to contact the court here to make this decision. They have all the same information, of course, and both parties have counsel up there. So I'm not involved in that except for giving them whatever we have here. And so basically this order is in effect until something happens. I mean, either the appellate court here does something different does something other than affirming the decision below. One of the courts takes jurisdiction, whether it's Canada or New York, and then usually along with that, they issue a temporary order. And if they don't, it stays in effect until they do. So that means that the child is now with dad until further notice. And we did say we were definitely open to doing visits with mom, but we have to have obviously some assurances that she's going to return the child and not go through all this again. But that is for another day. Right now, just letting my client get settled with his daughter and kind of take a little break from all this litigation that's been going on. I expect the court in Canada to take jurisdiction before anything happens with the appeal, making it moot, meaning that it no longer will have any effect. So it will actually, in my opinion, should be withdrawn by that point. But we'll see what happens. I'll definitely update if something changes. But this is, again, a really interesting case. Go back and listen to the previous notable approval if you missed it, where I went into more detail about this case. But what is interesting here, and one of the things I want you to take away is, and I get this question a lot, is my case over? Just because there's a decision, is the case over? And of course that depends on the case. But if there is an appeal allowed, then until those, I tell my clients in immigration court all the time, unless the government waives appeal, your decision isn't final for 30 days. They have 30 days to file a notice to appeal. They don't, that's your decision. And the same goes for the other side if we lose. I don't think anyone expected this thing to get appealed. It was very clear that mom was in the wrong. And in my opinion, even if this was my client, I would say this, I would have advised against this at first, especially. I think what the mom did makes her look even worse in terms of alienating the child from dad, especially her behavior the week following the stay. But, she basically just delayed him seeing his daughter another week for no reason. And, you know, she is already looking bad for what she had done. So I normally try not to jump the gun and talk about a case until I know it's over. I did jump the gun in this one a little because I was pretty excited, and I thought the chance for appeal, an emergency appeal to stay that order, was so slim. I was honestly in shock that it happened. But you know, it can happen. It doesn't mean it's over. Um, and that's always the thing with, especially in family law, when you're dealing with child custody, um, especially that's a really specific one where, you know, there's modification petitions can always be filed if there's a substantial change in circumstances. I've done modifications for relocations, for switching, you know, custody, when there was agreement, when there was disagreement, when substance abuse came into play, or criminal charges, for all sorts of reasons. So until your kids are emancipated at 18, you are, at least in the state of New York, you know, there's always that risk you can be brought back to court, and, you know, child support similar too. But you can get some finality once you have your initial custody termination, which is what they're still waiting on right now. So, you know, not trying to scare people that you can never be certain things are done or over with or final. But the fact of the matter is that, you know, you can do everything right and then still feel like the system isn't working properly. And it was a really hard thing, not just for my client and not just for me because I felt bad for him for the situation, but because I felt like the justice system was letting us down. And I feel that way, you know, it happens once in a while, or more than that sometimes. But I was happy to see it work properly and hope that it continues to do so. So don't give up. What you need is the right person really to fight for you. I didn't sleep basically until last weekend. Like, until I knew he picked up his daughter, I couldn't sleep. And there was fortunately no, although the mom would not confirm that she received the order and she was going to have the child ready for pickup. The child was ready for pickup and there was no issue there. So I was very relieved. But I wasn't going to stop until I got this man his child, because I felt that, you know, that's what he deserved and that's what the law said. And I will do that for all my clients. And if you would like an attorney who would do that for you, on Facebook and YouTube, my contact information is then scrolling across the bottom of your screen. On Instagram, you can go to our bio page and find it there. Also, don't forget to like us and follow us on Facebook and YouTube and Instagram, wherever you're watching. If you find this video helpful or know someone who may, hit that share button. And I think on our website, I have to double check with our marketing guy, but there should be a new ebook that you can download for free on marriage-based green cards. I will confirm that on my next show. I'm not sure if it's on the home screen or on the immigration page, but if you're interested in that, there's a lot of good information there. It's about, I wrote it all myself. It took me a while. There's some nice looking graphs to help you understand the process a little bit better, hopefully, as well. So that is all for now. Congratulations again to my client and his family. I know they are thrilled and relieved, and I wish them the best. I love like making money and handling cases, but I hope that this case stays in Canada, because I feel that based on the facts of the case, that's the right place for it to be. So I hope our upstairs neighbors, their justice system works just as good, if not better, than ours. So that is all for today. Thank you for watching and have a great day.